Hello and welcome to the August 2021 episode of My PIP Monthly. My name is Amber Rouse Holloway and I'm a partner here at our Troy office. Our August 2021 topics include, of course, a case law update. First, we'll discuss the case of Smith v. Everest National Insurance Company, issued July 1st, 2021. Then we'll discuss Insurance Property and Casualty Insurance Company v. MACP. And then lastly, we will discuss Bryce v. Johnson, which was issued on June 24th, 2021. And as for our trending topics in PIP litigation this month, we will discuss unlawful solicitation. First up is the case of Smith v. Everest National Insurance Company, which is an unpublished opinion which was issued on July 1st, 2021. Essentially, this case centers around the MCL 500-3106 parked vehicle exclusion and how the No Fault Act does not specifically define the term parked vehicle. By way of background, plaintiff was a tow truck machine mechanic who was performing vehicle maintenance while positioned underneath a parked tow truck when he was accidentally crushed by the tow truck's gas tank. The accident happened when the vehicle's wheels began to move, causing the tow truck to roll down the ramp on top of plaintiff. Plaintiff suffered a shoulder injury requiring surgery, a punctured lung, and several broken ribs. As a result of his injury, plaintiff received workers' compensation benefits through February 2019. At the time of the accident, plaintiff's wife had automobile insurance with defendant Everest. Plaintiff thereafter sued Everest for no-fault benefits, which were denied by the insurer. Defendant Everest went on to file a motion for summary disposition and argued that plaintiff was precluded from recovery of benefits under the plain language of the parked vehicle exclusion of MCL 500-3106, as plaintiff was performing mechanical work on a parked vehicle at the time of the accident and was therefore eligible for workers' comp benefits only. Everest further argued that plaintiff's attempt to collect duplicate recovery of no-fault benefits failed. Ultimately, the trial court granted defendant Everest's motion and found that reasonable minds could not differ that the tow truck, which was not operating on the road, not running, and up on a ramp with its wheels stopped for maintenance, was more likely than any other situation a stationary roadside object that could have caused plaintiff's injuries and was incapable of being readily put back into motion. The trial court viewed the tow truck as having been not literally motionless, but because it rode a short distance onto plaintiff, and that the absence of motion does not have to be relied upon for a vehicle to be considered parked. Ultimately, the trial court found that the tow truck was indeed parked within the meaning of MCL 500-3106, Section 2, Subpart A, and Everest's request for summary disposition was granted. Plaintiff thereafter appealed this decision, and the Court of Appeals pointed out that the No Fault Act does not necessarily define the term parked vehicle, and as a result of that, the court interpreted the statutory term in accordance with its ordinary meaning and generally accepted meaning as well. The Court of Appeals ultimately concluded that the limited record was insufficient to determine whether the tow truck was actually parked pursuant to MCL 500-3106. Due to the lack of discovery with regard to this issue and the nature of all the facts, the court found that a genuine issue of material fact existed as to whether the tow truck was parked at the time of the accident. Thus, the Court of Appeals ruled that the trial court erred in its decision granting summary disposition as to Everest. Next up, we have the case of Insurance Property and Casualty Insurance Company v. MACP. This case centers around the Supreme Court addressing when a no-fault carrier can actually step into the shoes of an insured person and attempt to recover payments it made to that person in error from a higher in priority carrier. Of note, Secret Wardle represented Esurance in the trial court and on the appeal in this case. By way of background, Esurance filed the subject lawsuit against the MACP seeking reimbursement for PIP benefits Esurance paid to a Rashawn Edwards for injuries Mr. Edwards sustained in a single vehicle crash. Edwards did not have no-fault insurance at the time of the accident, did not live with a resident relative who had no-fault insurance, and therefore the MACP was assigned. At the time of the accident, the vehicle Edwards was driving was registered in Michigan and titled to an Anthony White, who also did not have no-fault insurance of his own. The vehicle was insured by Esurance under a Colorado automobile policy issued to Anthony's mother, a Luna Edwards White. When Luna obtained the policy, she falsely represented that she owned the vehicle and that she lived in Colorado and that the vehicle would be garaged in that state. Following the accident, Edwards sought PIP benefits from Esurance, and Esurance began paying those benefits. Edwards also applied for benefits from the MACP as administered by the MAIPF, but the MAIPF did not assign a servicing insurer to the Edwards claim because Esurance had already taken responsibility for the PIP benefits to Edwards. When Esurance eventually discovered that Luna had obtained the Colorado policy through her fraudulent misrepresentations, it obtained a judgment against Edwards, Anthony, and Luna that rescinded the policy. Esurance then filed the subject equitable subrogation claim, requesting an order requiring defendants, the MACP, to reimburse it for all of the PIP benefits it paid to Edwards. Both the MACP and MAIPF moved for summary disposition under MCR 2.116C8, arguing that there was no legal basis for the claim because the No-Fault Act did not contemplate reimbursement and indemnification rights in these circumstances. Esurance argued that it can stand in Edwards' shoes and pursue the claim through the doctrine of equitable subrogation. Edwards could seek recovery from the MACP and MAIPF because Edwards had timely filed for benefits from the MACP and was not covered by a no-fault policy. The trial court accepted the MACP and MAIPF's argument, finding that because the statute was silent about equitable subrogation, the claim did not exist. The Court of Appeals affirmed the trial court's decision on different grounds, though. The panel found that Esurance equitable subrogation claim failed because, one, the policy existed when Esurance paid the PIP benefits, in which case Esurance equitable subrogation claim failed because Edwards could not pursue the benefits from MAIPF or MACP, or two, the policy was void, in which case Esurance was a volunteer when it paid the benefits and therefore could not recover them. The panel disagreed with the trial court's finding that the statute foreclosed equitable subrogation. Rather, the panel found that the remedy was not available under the specific facts of this case. Esurance then applied for leave to appeal to the Michigan Supreme Court. In lieu of granting leave, the court reversed. The 5-justice majority held that when a paying insurer has at least an arguable duty to pay benefits under the No-Fault Act, the insurer is simply protecting its own interest and not acting as a volunteer, and therefore it may invoke the doctrine of equitable subrogation. The mere existence of an insurance policy that covers a claimant does not render it a policy applicable to the injury. Instead, to determine whether there is an applicable policy, courts must perform an order of priority analysis. In this specific case, the Esurance policy was declared void after the accident. However, at the time of the accident, Edwards did not have no-fault insurance, and he was not a relative of someone who had no-fault insurance, a resident relative, that is. As a result, he was not covered by the policy issued by Esurance, and Esurance was neither in priority under the order of priority because the vehicle was owned by another person not insured by Esurance, and the operator of the vehicle, Edwards, who also did not have a no-fault policy and also did not live with a resident relative who had a no-fault insurance policy. Because there was no policy that applied to the injury under the order of priority analysis, the facts alleged in Esurance complaints supported that Edward had a viable claim for PIP benefits against the MACP and MAIPF. Also, although the Esurance policy was not in the order of priority before the policy was rescinded, it believed it was because of Luna's misrepresentations in her insurance application. As a result of that, Edwards was not a volunteer when it paid the benefits because it did so under erroneous impression of both the facts and its legal duty. It's also important to note that the Supreme Court majority further clarified that the Court of Appeals reasoning that Esurance's equitable subrogation claim failed because the policy was applicable under MCL 500-3172 or because Esurance payments to Edwards were voluntary. The court held that that whole rationale was erroneous. The Court of Appeals, however, was correct in rejecting the reasoning that the trial court, that the statute is silent about equitable subrogation. And last up for our case law update, we have the case of Brees v. Johnson, issued June 24th, 2021. This is also a case that talks about some material misrepresentations in applications for insurance. Here, the court analyzed whether a no-fault insurer is entitled to rescind the insurance policy against the plaintiff when a plaintiff's mother made the misrepresentations in the procurement of her insurance policy, not the plaintiff, him or herself. Ultimately, the Court of Appeals affirmed the trial court's decision and held that questions of fact preclude summary disposition against the plaintiff. By way of background, plaintiff Shania Brees was injured in a motor vehicle accident. Shania brought an action against Citizens pursuant to a policy of no-fault insurance issued to her mother, Tammy Brees. In her applications for insurance, Tammy represented that all the vehicles were registered by her alone and kept at the policy address. Tammy thereafter added a Pontiac G6 to her policy, which was registered in both her and her daughter Shania's names and registered at Shania's address, not her own. An accident happened thereafter, and following the subject accident, DMC provided Shania medical services. Citizens did not issue payment and began an investigation, which led to the discovery of the mother, Tammy's misrepresentations. After Shania filed her actions, the Citizens filed a third-party complaint against Tammy and DMC, as well as a counter-complaint against Shania. Citizens sought a declaration that it was not obligated to provide Shania PIP benefits due to Tammy's misrepresentations, both involving the garaging of the vehicles and the ownership of the vehicles. Both Citizens and DMC filed motions for summary disposition. Citizens argued that Tammy's misrepresentation prompted rescission of the policy. The trial court initially denied both motions for summary disposition, and also DMC argued that there was no dispute and it was entitled to payment. The trial court denied both motions because there were questions of fact as to, one, whether the amounts charged by DMC were reasonable and necessary, and two, whether Tammy committed fraud. Even if Tammy did commit fraud, Shania was an innocent third party and it would be inequitable to rescind the policy. Rather than granting leave to appeal, the Court of Appeals vacated the trial court's order to deny Citizens' motion for summary disposition and remanded for further proceedings. The court noted that there was no genuine issue of material fact that Tammy made material misrepresentations in her application for insurance. The court remanded for further proceedings to determine whether equity favored a finding of rescission. And the trial court was ordered by the Court of Appeals to undertake an analysis of a 5-factor test as outlined in the Pioneer State Mutual Insurance Company v. Wright case. The 5 factors that the court was to use are: 1, whether the insurer could have uncovered the subject matter of the fraud before the innocent third party was injured; 2, the relationship between the fraudulent insured and the innocent third party to determine if the third party had some knowledge of the fraud; 3, the nature of the innocent third party's conduct, whether it was reckless or negligent in the injury-causing event; 4, the availability of an alternate avenue for recovery if the insurance policy is indeed rescinded; and lastly, 5, whether providing coverage relieves the fraudulent insured of personal liability to the innocent third party. On remand, the trial court ultimately denied rescission by holding that 4 out of the 5 factors weighed against rescission as to plaintiff Shania, the innocent third party. Citizens then initiated another appeal. On appeal, citizens argued that the trial court erred in its analysis of the Pioneer factors, these 5 factors. The court disagreed after applying the present facts to each Pioneer factor, while emphasizing the factors are non-exhaustive but are meant to serve as a guidance. The court held that the Pioneer factors were either neutral or weighed in favor of providing Shania with coverage. The first factor did not weigh in favor of or against rescission. The second factor weighed against rescission. Shania and her mother, Tammy, did not reside in the same household, and the custom agent testified that he never actually spoke to Shania herself regarding procurement of the citizens policy. And the third factor was also favorable to Shania. Even though she was not wearing a seatbelt at the time of the accident, she didn't negligently or recklessly cause the accident itself. The fourth factor weighed against rescission because the 1-year back rule barred Shania from recovering from the MACP, and her health insurance did not provide lost wage benefits. And the fifth factor was neutral. As for our trending topics in PIP litigation, I wanted to discuss the unlawful solicitation of a plaintiff, named insured, or injured party. Under MCL 500-3157, only a clinic or institution rendering lawful treatment to an injured person for an accidental bodily injury may charge a reasonable amount for the products, services, and accommodations rendered. We've all heard this line, but in this specific instant, we want to focus on the words lawful treatment. The Michigan Penal Code also criminalizes and doesn't allow solicitation of an individual injured in a motor vehicle accident or an immediate family member of that injured individual for any reason within 30 days of the motor vehicle accident. Specifically, MCL 750-410B provides, a person shall not intentionally contact any individual that the person knows has sustained a personal injury as a direct result of a motor vehicle accident or an immediate family member of that individual with direct solicitation to provide service until the expiration of 30 days after the accident. The Michigan Penal Code goes on to say that a person, firm, co-partnership, association, or organization of any kind, whether incorporated or unincorporated, or any of the officers, agents, servants, employees, or members of any such person, firm, co-partnership, and association who shall directly or indirectly solicit a person injured as the result of a motor vehicle accident for the purpose of representing that person and making a claim for damages or prosecuting an action or causes of an action arising out of a personal injury claim against any other person, firm, or corporation to employ counsel for the purpose of that solicitation is guilty of a misdemeanor. So what exactly is unlawful solicitation? Well, under Michigan law, it is the verbal or written solicitation or offer, including by electronic means, made to an injured individual or a family member seeking to provide a service for a fee or other remuneration that is based upon the knowledge or belief that the individual has sustained a personal injury as a direct result of a motor vehicle accident, and that is directed towards that individual or family member. The Michigan Supreme Court has repeatedly determined that if an act is unlawful according to the Penal Code, it is unlawful within the No Fault Act, regardless of whether the act was pursued criminally. Therefore, solicitation is unlawful and therefore not compensable under the No Fault Act. And as you may recall, only an institution or a clinic rendering lawful treatment to an injured person may charge a reasonable amount. And that is all I have for the August 2021 episode of my PIP Monthly. Again, my name is Amber Holloway. Please feel free to contact me with any questions and/or concerns. Thank you.